All right, let's stay then with this very story and speak now to Professor Cathy Powell, an Associate Public Law Professor at the University of Cape Town. Prof, thank you so much for your time this afternoon. Your reaction to the ruling, some say that it was always going to be this outcome.
Yes, I agree. It was a non-starter for Advocate Mkhwebane to have brought the case in the first place. And part of the cost order against her is for that very reason, that she fought a case which she knew was unwinnable. Now, so yes, it could not have had any other outcome.
Pardon me, Prof, for coming in there. Some have said that cost orders, and she said it herself, that they kind of used to deter those who want to challenge the law. And some are saying that this is the case in this particular matter. I wonder how you respond to that.
They are being used as a deterrent. But what the court here is trying to deter is people fighting hopeless cases and refusing to let an issue go that has already been decided not only by the Western Cape High Court but by the Constitutional Court. Remember that we're dealing with a case here where the Public Protector is trying to get the Western Cape High Court to stop Parliament from carrying out its constitutional duty of oversight over her office, the Public Protector. Parliament must stop while she, the Public Protector, asks the Constitutional Court to reconsider for a second time whether it made the right decision 2 times ago. Now, if you can stop Parliament from doing its job simply by saying to the Constitutional Court, are you sure? Are you really, really sure? Then this proceeding will never happen against the Public Protector. And it's one of Parliament's jobs to make sure that the Public Protector is doing her job properly. And there's enough evidence, we've had an independent panel showing us this evidence to show that there's a huge problem. And if Parliament were not to engage with that problem, Parliament would be failing the people of South Africa, not doing its duty. So what the court said was, we're not going to allow this process to be held up by non-existent legal claims.
And one of the things that even the court points towards, especially when you talk about this parliamentary process, is that she appears to say that she will suffer should this process continues, because she has been saying in various interviews, including one that I had with her, that she feels that the people who are presiding over this this process are going to be not independent. They already have made up their minds about her. I wonder how much of a complication does that add then to this particular process as it unfolds? Could we see a lot of stops?
Well, as the court pointed out, she has every right to take Parliament's decision about her once they reach their decision on impeachment on review. So yes, she can go back to the courts and say they were biased. Parliament was biased. But the court in this judgment this morning actually deals with that point of bias in some detail, because they point out that Advocate Mkhwebane does not bring any evidence of bias. What she brings is her own personal feeling that these people are biased against her and that they've made up their minds. But the court was unsatisfied that Advocate Mkhwebane had actually met the threshold required to establish that there was in fact any bias. It's always going to be a problem when you bring a case against somebody when somebody has to make a decision about you and you're investigating that person. But that's a problem that judges have, and there's a very high test for bias for judges, and the court referred to that here, and it said there's actually absolutely no evidence that the Public Protector's brought that there's real bias here. And we must bear in mind that that decision to suspend was made on the basis of a very thorough report showing a serious, plausible prima facie case of misconduct and incompetence on the part of the Public Protector.
And Prof, one of the things that, we also saw, of course, as part of this particular court challenge, she was also seeking the court to bar the president from suspending her, but we saw that happening last night as well. Some have questioned the timing of her suspension just a day before the court is to make a decision. Do you think there's validity to these concerns, particularly using, looking at the fact that others are now using that SMS at some point that was sent by Ishmael Abramji talking about that rescission application? So they're lumping all of these together to say it was a predetermined outcome. Is there validity to these concerns?
Oh, no, I don't think so at all. I think the reason that the suspension had to go ahead was that it was part of the work of Parliament, which the President was participating in at that point. And as the court has now confirmed, and as the court in fact said the last time, and the Public Protector ignored the court the last time, the National Assembly Parliament must carry on doing its job. It would be a violation of the doctrine of separation of powers if the court were to stop it. So if Parliament keeps waiting to see if the court's happy with what it wants to do, then in fact it's the court that's running the country and not Parliament. The court is already in a previous judgment that the Constitutional Court has approved of the process that Parliament is using. And it is required then for Parliament to carry on with the project, with its job. I think the best thing that the President could and should have done was to ignore the court process there, and I think that's what he did do.
And Prof, as a final question, let's talk about this, this committee now. It's going to begin its work, and some have even raised concerns around, the fact that she may have legal representation, and if she does, that might further complicate some of the questions she may or may not be able to answer, and it might make things difficult when it comes to accountability.
Look, I think holding Advocate Busisiwe Mkhwebane to account is proving to be a gargantuan task. We've seen that already. We're 2 years into a complaint having been laid against her. So yes, I think it's going to carry on being as complicated as she and her legal team can make it. I think that will do damage to our constitutional democracy, but I'm glad that Parliament is finally rolling up its sleeves and actually doing the job.
Prof, thank you so much for your time, and we'll talk and see if, as time goes on, this inquiry, when it unfolds, what then do we see unfolding in terms of the law. But let's leave it there for now. That was UCT Associate Public Law Professor Cathy Powell.